Hello. Most of you are here today for your first appearance. That is your first opportunity to appear before the court and enter a plea. Before we can do that, there are a few things that I need to go over with you. First of all, the Constitution of the United States mandates that you be advised of the severity of your charges. That means that we have to tell you the maximum penalty that you could face in your particular circumstance. We normally do not impose the maximums. However, we are required to tell you what those maximum penalties may be. Because we don't normally impose the maximums, we will also tell you what we normally do in similar circumstances. The next thing that we're going to address is your right to an attorney. In any case, you have the right to hire an attorney of your choosing. The only requirement is that they be licensed to practice law in the state of Kansas. If you are charged with a traffic infraction, such as speeding or disobeying a traffic signal, then you do not have a right to a court-appointed counsel. You can still hire one if you choose, but you do not have a right to a court-appointed attorney. If you are charged with an offense that may have a jail sentence associated with it, then you do have a right to a court-appointed attorney. If you would like to request a court-appointed attorney, please let me know and we will give you an affidavit to fill out. You will complete that financial affidavit under oath, and upon completion, if we find that you are eligible, we will appoint an attorney for you. Please note, it is not an attorney of your choosing. These are attorneys who have agreed to serve on our panel. Additionally, if you are convicted of your offense or a reduced charge, it may be required that you reimburse all or a portion of the attorney's fees for the assigned counsel. In other words, having a court-appointed counsel isn't necessarily going to be free. It is normally at a reduced rate, but it is not necessarily at no expense to you. Your final option is that you have the right to waive your attorney. Many people choose to do this. They simply want to resolve the matter and they don't want to go to the expense of hiring or having a court-appointed attorney. If you do wish to waive your right to an attorney, we'll have you sign a waiver of attorney, which states that you understand you do have the right to an attorney, that if you couldn't afford one, that we would appoint one for you, but you wish to proceed today without one. Once we complete that portion, I'm going to ask you how you would like to plead in the case. There are 3 pleas that you can enter in any case. The first is guilty, which means you acknowledge that you committed the infraction or offense for which you are charged. The second plea that you may enter is no contest. A plea of no contest is neither admitting nor denying any of the charges against you. It is merely your statement to the court that you wish to proceed with the matter, that you do not wish to contest it, and if you enter a plea of guilty or no contest, if I accept that, I will find you guilty and will proceed to sentencing in your case. The final plea that you can enter is a plea of not guilty. If you enter a plea of not guilty, your matter will be set down for trial at a later date. At a trial, it is the burden of the city to prove you guilty beyond a reasonable doubt. Because the city necessarily has to present witnesses or evidence to meet their burden, your trial will not be today. We will have a trial, but it will be at a later date when the witnesses or evidence can be present. You will also need to be present at that date with any witnesses or evidence that you choose to present. There are a few final matters that I want to explain to you as well. In municipal courts, you always have a right to appeal the decision of the court, either your conviction or the sentence imposed. So if you are dissatisfied with the conviction in your case or the sentence that is imposed by the court, you always have a right to appeal. You do that by filing a notice of appeal with the clerk of the district court. That notice of appeal has to be filed within 14 days of the date of your conviction. If you do not file it within 14 days of the date of your conviction, then you will lose your right to appeal the matter forever. If you do file a notice of appeal, the district court will hear your matter from the beginning. That is a standard we call de novo. That means your case will be heard in its entirety. So if any charges were dismissed through plea negotiations, those could be reinstated as part of the appeal. You also need to be aware that anything you can be convicted of in municipal court is subject to expungement. That means that any offense that you could be convicted of here if you stay out of trouble for a period of time, can be removed from your record. An expungement is a process where you file an application with the court and indicate to the court that you've stayed out of trouble for an applicable period of time, normally at least 3 years, sometimes longer, but that you have stayed out of trouble, that you've not had any further violations. If the court finds that is in fact true and you've met the statutory period, then your conviction would be expunged and removed from your record. That means if anyone ever asks you if you've ever been convicted of a crime, you can honestly say no. The final thing you need to be aware of is that any conviction of any municipal charge, whether an infraction for a traffic offense or a misdemeanor violation, could subject you to immigration consequences if you are not a citizen of the United States. We have covered a lot of information in this time, and if you have any questions about any of the statements made or about any of the process through your proceedings, please be sure to ask the judge, ask the clerk, or ask your attorney. It is extraordinarily important to us that you understand what is going on in your case and that you get all of your questions answered. If you do have any questions, please make sure to present them to the court or the clerk before you leave. Thank you for your attention.